weekly Los Angeles real estate investors.com official podcast. We get together every Tuesday at 3 p.m. Pacific time, 6 p.m. Eastern, and talk about all things real estate investing. We do live stream this to YouTube and Facebook. We record it as well there. And this is affiliated with the LA Real Estate Investment Club, or LARIC.com website, which has an event in town every month, and on the second Thursday of the month here in Los Angeles. And so we bring in guests as well as different vendors to talk about all things real estate, whether you're an investor, wholesaler, want to get started, a real estate agent or vendor. We love to talk about all things real estate. And I've been doing this call for a couple of years now, 2-3 years in one format or another. And one of our regulars who's contributed all along, and I never really thought about having him as a guest. I don't know why, but maybe I did and he was busy, or maybe he was too shy. I don't know. But anyhow, I called him up and said, Jack, we need to have you and find out what you do and share with you. I referred a couple people to you recently, and I need to know more about what you do. So I'm really glad to have Jack LaPedis, who is really an attorney. He really is one. I know it's true because it says that on the graphic on top of him. He's dressed like an attorney in the graphic to his side, and then he has a QR code. So that must make him official. So Jack, welcome to our call today.
Thank you. And I haven't recently been called shy, so thank you very much for that.
Give us a background. Where'd you grow up, and then how did you get into the practice of law?
Okay, well, my sister's on the call, so I can't lie about my upbringing anymore. I was born in San Francisco, and I grew up in a suburb of San Francisco called Daly City. And if you know the geography of the Bay Area at all, in effect, if you take Daly City out, San Francisco becomes an island. So it's most of the southern border of San Francisco, right next to San Francisco. I left for college from the same house that I came home from the hospital to. My parents were in that house for 39 years before they moved down the peninsula. I went to high school in San Francisco proper. So I got a little bit of cred there. And then I went to UC Irvine for undergrad and got a degree in psychology, though I started there as a computer science major. And for those of you who know me a little bit, I collect Apple hardware, computers, phones, and the like. And that was something that was with me early on, was my love of computers. I then went to Pepperdine University Law School and graduated there in 1995. And I've been an attorney for about 26 years at this point.
So when somebody asks you your elevator pitch, what kind of law do you practice? What's the shortest answer?
The shortest answer is the really short answer is I do real estate and business disputes, which really doesn't give you a ton of information because when I say real estate, they say landlord tenant, which is the wrong answer. Most of my cases involve neighbor disputes. So a lot of what I do is disputes having to do with people's homes. So purchase and sale issues with mostly residential, real estate professional disputes, whether it be with a client or another professional, such as commission disputes, or if the client, like the seller, wants to get out of their listing agreement. I've handled both sides of that. I've helped home inspectors. I handle remodel disputes, whether it be for the homeowner or the contractor. I have a background in construction defect litigation, so I know my way around a 2x4. I have a little more difficulty with 4x4s, but that's a different story. But again, most of my cases are neighbor disputes: shared trees, shared driveways, shared fences, property line issues, easements, noise complaints, and I like to tag on there, and sometimes even a little bit of violence. And then I also help small businesses with contract and vendor disputes, co-owner and partner disputes. And I also help brick and mortar locations with ADA claim avoidance and ADA lawsuit defense. I also have a small part of my business not related to real estate where I represent people who have been wrongly accused of financial elder abuse. So like a caregiver or a family member who's been assisting an older person, and some family member comes in and says, oh, you've been stealing money or whatever like that. And I emphasize I only represent people who have been wrongly accused of that. I don't represent bad guys.
So that means based on your, well, that's a whole fascinating array there for number one. Number two, the last one, well, not really germane to our topic here today, is Sounds like a fascinating topic on its own. Let's talk about real estate disputes. One of the things that seems to hold first-time investors back is the fear that they're going to get into a transaction that they can't get out of. As a practitioner, I've never seen that happen unless a mistake was made by a practitioner, maybe a colleague or somebody on the other side. Do you see those kind of disputes where a buyer, let's say, puts up a earnest money deposit, 3% most commonly, and then wants to get out, and without waiving all their contingencies, has difficulty getting out? Do you see that happen from time to time, or is that a fairly safe area for most buyers?
As long as the contingencies haven't been waived and the time periods haven't run, I have not personally seen a matter come across my desk where the person couldn't get out of the sale. I'm not saying it doesn't happen, but usually the real estate professionals are able to handle that situation well enough that it doesn't turn into something where you get a lawyer involved. The only time you get into trouble is when you start waiving contingencies and you make the deposit non-refundable and that sort of thing. I've handled a number of those kind of matters, and that's a mistake. Either the buyer insists on making, or that the professional representing the buyer allows them to make.
So, and then just to clarify, make sure I'm right on this, my understanding of the law is when you make an offer as a buyer, you have contingencies, which means that if these things aren't met, you can cancel and get your money back. And that in the standard CAR form, unless you change it, that waiving has to be done actively, meaning you have to, as a buyer, say, I agree to waive my loan contingency, I agree to waive my appraisal contingency, and even if it drags out past that point, you're going to get your money back at the end of the day, most likely. Is that generally true?
Generally speaking, some of the contingencies, the way the language is written, it says, you have X number of days, or when you waive it, whichever comes first. And so there are some time limits, and there are times where if you blow a date, I wouldn't say it'd be impossible to get your money back, but it just makes things more difficult. And it probably emboldens the seller. So, oh, well, he blew the date. And again, right. Sometimes the sellers don't understand what it means. I can't tell you how many times I've had to explain to people what the term as is means in a real estate contract. It doesn't mean what you think it means most of the time.
What does it mean?
Funny you should ask that question. So
well, you left me hanging there, Jack.
Yeah. Well, I didn't want to assume. No, as is doesn't mean here you go. I don't have any liability or responsibilities at all, which is what a lot of people think it means. As is means in the condition it's in on the day that we contract for it. And that doesn't relieve the seller of duties to disclose known material issues, which is, there's been a flood in the house, or there's mold, or all the things that you're supposed to disclose. You still have to disclose in an as-is transaction. And the as-is transaction means you, the seller, can't start ripping down walls. You can't start taking off light fixtures, or in the case of when my parents bought their house, the people took all the light bulbs out of the house, things like that. And it's no sort of guarantee, or it's no sort of waiver. It's just we are buying this house as it stands here today.
Right. Or as I try to explain to people at the walkthrough, it's as was, not as is, meaning you can't destroy the place after we enter a contract and say, well, that's how it is. It's as it is the day we signed the contract, or as was as we sit here today. And the seller has a duty, and it's even written in the standard CAR forms, California Association of Realtor forms, that the seller has a duty to maintain the property in the current condition. Of course, what that means, I'm sure, is debatable, but they have a obligation to maintain it in that same condition through the end of the escrow. So, right. Okay, good. That's a common one. And the other one is as is. Sometimes sellers think that means that no matter what I disclose, the buyer has to accept whatever it is we disclose or whatever they discover. But really, that doesn't mean that we're never going to negotiate. It means the buyer can either say, give me credit or I'm willing to cancel, right? It doesn't really strengthen the buyer's hand anyway, does it?
Correct. It doesn't change anyone's position or anyone's rights or duties. All it does is, like you said, it's like as was or as it is on the day that we contract to sell and purchase this piece of property.
So, what are the most common disputes that you see people get into that they could have easily avoided? Like, is there a couple common ones that you say that just doesn't make sense, but somehow people keep making that mistake over and over again? Is there anything that jumps off the page to you?
Well, I think what I have found is, in a buyer's market, sellers keep making mistakes, and in sellers markets, buyers keep making mistakes, and
Right.
they're, or at least perceived mistakes. Like we just came out of a situation where in about a year, I'm going to see a lot of lawsuits of buyers suing sellers for non-disclosure because they overpaid for the house and they need to pay their mortgage somehow, so they're going to want to get some of that money back. And then the reverse becomes true, where you have when it was a buyer's market, you'll about a year later you'll have sellers suing their agents for letting them sell the house for too little. That's sort of a constant pattern that I've seen. I don't know if I say the most common mistake, I guess, is where the seller says to the agent, "Do I need to disclose?" And the agent doesn't immediately say yes. Now, it doesn't matter what it is. If you ask the question, you have to disclose it. And then sometimes you have sellers, of course, who won't even ask the question because they know they're going to have to disclose it and they don't want to. So the purposeful non-disclosure issues are the mistakes that sellers make a lot.
Okay, so let's go back a little bit. Disclosure. My general rule, as I say to a seller, is if you're asking me, should you disclose? The answer is if you know it to be, then you know it to be. If you don't know it to be, you don't know. But if you know it to be, then you need to disclose it. That's what the nature of a disclosure is, right? Sometimes
Right.
I've had sellers say to me, well, I heard somebody say that they heard that. You can't disclose somebody told me. You can disclose what you know, or you can't, or disclose what you don't know. If you know something happened, you have to disclose it. Do you see sellers purposely hiding things? Or you think it's just negligence? They forget to be comprehensive when it comes time to make disclosures.
I've seen sellers paint over mold, so that was pretty purposeful. That was a while back, and that was out in Santa Barbara, where every house has mold.
Right.
I've had situations where I had a case that I handled where there had been a flood underneath the kitchen sink, and the father-in-law came in and fixed it, and they dried it up, and it was fine. And 5 years later, they sell the house, and they don't disclose that there was a flood under the sink, because who would really think of that? And the buyer who overpaid for the house decided to sue, and they found out about this. I called it a flood. It was really a leak. And that was one of the things they sued about, was that you didn't disclose this because our son is susceptible to mold, and now we have to tear out the whole kitchen or whatever. So that's when we bought our house, I'm in my house now 15 years. The first week we were here, we had a toilet overflow in we call it the powder room, small bathroom, and it's hardwood floors, and it got all wet. So I dried it up, and I made a mental note: when I go to sell this house, I'm going to disclose that in whatever it is, 2007, we had a leak or a flood in this bathroom, just because I know it, and if I disclose it, they can't come back at me. So there's those things where you don't think you need to disclose it. But that's why, again, I say if you're even thinking about whether you have to disclose it, just disclose it.
Yeah, as a good general rule, if you're thinking about it, if you think you might need to, then you probably have to write it down and disclose it. And usually that will not. Excuse me? Okay, thank you. Sorry, the air conditioning repairman's here, and of course my wife's gone. So just to add to the confusion, I saw the dog in the background. Classic pandemic era marketing. Okay.
Right. You can't get sued for something you disclosed.
I'm sorry?
You cannot get sued for something you disclosed.
Right. The fear the seller always has is, I disclose that they might back out or they might ask for credit. And the answer is better that than close escrow, go on your merry way, and then get sued, because that's a lot more expensive and more painful down the road.
Yeah.
I think the ultimate disclosure is somebody dying in the house. I had a case where my seller didn't disclose it to me until after the buyer waived all contingencies. We were in escrow for like 45 days, and day 46, I discovered he was wrong. I had the death cert, and I went to him, and he was just emotional about it. He didn't want to confront the reality, and we had disclosed the buyer. Of course, the buyer could back out. I mean, that's the worst case. He didn't, as it turned out, but and it worked out for everybody. So,
Right.
so you said that sometimes sellers can come back and sue for a property being sold for too little. What does that look like? What's the basis for that claim? And then what can a real estate agent do to protect themselves from that?
Well, the claim essentially is professional negligence, that the reason why you hire a real estate professional like a real estate agent is to advise you. And one of the main things they advise you on is how much to sell the house for. And if you sell the house for, less than market value or significantly less than market value, I mean, everyone has reasons for why they might want to sell a house quickly or whatever. But if it's, below the standard of care for a real estate agent to suggest that you sell it for a certain price, you can get sued for professional negligence. And the way you protect yourself from that is to run comps, or there's another term. It's not comps. It's like an agent's opinion or some sort of thing like that. And
Broker's price opinion.
Yeah, price opinion, which, by the way, I've had cases where the person thought it was comps and it was actually a price opinion, and so they sued because they thought they were misled. So that has its own, I mean, as I tell people all the time, you can get sued for anything. It's a matter of whether you win or not, but it's going to take your time and money and affect your insurance.
Just stop for 1 second. Just say that again, because my father used to say it to me all the time. And I say it to people and they look at me like I'm crazy. Now, we all look at you like you're crazy, so that's okay. Just one time, can somebody sue anybody for anything?
Yes, absolutely. You can sue someone for anything you want. The question is, how much time do you want to spend defending it, and how quickly can you get rid of it? And on the other side is, can you win? So, for most real estate professionals, they have insurance, which is where I came in a lot of the time. For about 10 years of my career, I was working for the insurance companies defending real estate professionals from these kinds of lawsuits. But at the same time, you have to pay your deductible. You have to take time out of your life to answer discovery and meet with your lawyer and perhaps go to depositions and, God forbid, go to trial. And, it's not fun. It's not even fun for the lawyers, to be honest, but, you don't want to spend your time doing that. So the more things you can do to make it impossible for the other person to sue you, the better. So if you run comps and you have documentation that you get nowadays, you email or text it to them, email is preferred, proof that you sent it to them, proof that they acknowledged receiving them, that they reviewed them, as long as you're not way outfield on your comps, you're in Sherman Oaks and you're doing comps from Woodland Hills, which I think is pretty far afield, you should be okay. But again, there's also crazy people who will sue you for, putting voices in their head to convince them to buy the house. And I've had that case too. So there's only so much you can do.
Yeah, and I think, two things you can do that aren't really related to law is, one, when they start crazy, my experience with customers is when they start crazy, they never get less crazy. I've never had a client who was crazy who in the middle of an escrow got real therapy and ended up being normal. It's kind of the opposite. If they start crazy, they have permission to get crazier. And I think the second was that for most people, it is emotional. I always find that if you just make the extra phone call or the extra time on the call, well, people at least feel like they're heard. The one thing you don't want somebody to do is feel like you're not paying attention to them, because then you just put fuel to the fire of them wanting to do something, lash out, which might be a lawsuit. So,
yeah, Bill, you and I are reading from the same notes, because one of the things I tell people, especially other independent lawyers, is bad clients rarely turn into good clients, which you just said. And the other thing that I do in my practice that I came up with is because I used to do legal malpractice defense. So I represented lawyers who had gotten sued by their clients. And the number one reason why a lawyer gets sued is lack of communication.
Yep.
And so one of the things I do is I BCC my clients on every email, no matter who it's to. So they always know what's going on. And nowadays with email and text, as a real estate professional, there's no excuse for your client to not know what's going on. And if there's something going on, you're like, oh, I don't really want to tell the client that, you need to take a step back and start over, because the client should know more than, if not, at least as much as you do, if not more than, regarding the transaction they're dealing with.
Yeah, that's a good point. I use Google Voice, which among other features forwards all my voicemail and text to my email. So it's very easy to create a record on transaction of all communication. And like I said, I can set up an auto forwarding. They get everything. Some people want it all, some don't, but it makes it easy to do that. And I think it's a minimum standard today to keep records of all your communication, because, then it's he said, she said. And that's why I like communication in text rather than phone calls. Not with my client, but with the other party, other agent, because then there's a record of what he said. It's not what I said or you said, it's what the text says.
Well, it's a little different for me, but one of the things I also do is I also use Google Voice for my office phone. And whenever I get off a phone call, I screenshot the record of the call and email it to myself, and I put that in the client's file. So even though I don't have a record of exactly what was said, though I usually follow up with an email, I certainly have a record of exactly when we spoke and for how long.
Yeah.
So if they come back and say, he called me and left a voicemail and that was it, and I have a record that we had a 15-minute phone call, that's going to be helpful.
Yeah, I love that. I love when people say, well, you never return my phone call, and I go in and search. So usually it's a real estate agent. I'll search their phone number and pull up all the phone calls will show out, in, out, texts, voicemails, and I'll send the email and say, well, here's a record of every conversation we had. I forced myself to do that. So you mentioned, we talked a little bit about selling for too little. Then on the other side is working with buyers who might sue. And I can imagine that coming up right now, saying they paid too much, because there were times where buyers just paid anything to get a property. And for a year or two, that worked really well. And all of a sudden, I don't know, I would say that the music has stopped, but it's certainly slowing down, runs the risk of it stopping. What is it that causes somebody to pay too much? What's the cause that the agent did wrong? And what can they do to avoid that?
Well, usually when they pay too much, for some reason, they don't tend to blame their own agent for letting them pay too much. What they usually do is they blame everyone for not disclosing the supposed problem with the property. When I first started doing real estate law, it was all about mold. People would buy a house and they would overpay for it, and they'd start a remodel and they would find mold. And like I said, a lot of my cases were in Santa Barbara, and I'm telling you, there is not a house in Santa Barbara County that doesn't have mold. That's just the nature of the beast, the proximity to the ocean and the direction of the wind and all that kind of stuff. So what the buyers would do is they turn around, they sue their agent, the other agent, and the seller, saying, you knew or should have known about these problems, the mold, or there was a remodel that wasn't up to code, even though it had permits and inspections. A lot of them were marginal to frivolous that I found. Every once in a while, like I said, there was a case where a guy painted over visible mold, and we just so happened to, we were able to determine that had happened before my client, the real estate agent, got involved. There are real sellers who really do try to hide stuff, but a lot of them were when you're in a seller's market and people are overpaying. Well, in the seller's market we just had, people didn't have to do that, to be honest. They basically said, yeah, it's got mold. You want it or not? I got 10 people lined up buying this moldy house. It was back when it was a buyer's market for whatever the reason is. You ever have a buyer's market before? That's when you still had people who they didn't have 10 people lined up. They had 2 or 3 people lined up ready to overpay. And so they tried to make the house look as good as possible.
And so as an agent to protect yourself in that circumstance, I guess the answer there, all you can do is disclose. With mold, we have disclosures. They have the opportunity to inspect if they want. But I guess at the end of the day, they may find mold later anyhow. There's really not a lot you can do as an agent. What is there anything particular you can do to protect yourself as a seller from a buyer claiming you sold too much, or other than just be diligent disclosing?
I think that a lot of agents don't take the visual inspection as seriously as they should. I think that
Guilty, by the way. I'm probably one of them.
yeah, I think that at a minimum, the agents, when they walk into a room, they really need to look up and look in the corners and look in the cracks and see if they see any evidence of water, any water damage, old or new. And if they do, they need to note it in their disclosure, and they need to talk to the client about it. And if the client says, oh yeah, that's we had a leak in the roof 5 years ago and we just never painted it, then you put that in the disclosure. And that's what you know. You're not required to go climb up into the attic and see if it's active. You're not required to take samples to find out how old the water is or what. But just walking in the room and paying attention, and this is my third inspection I had to do this week, and so I'm just going to walk through and look around. And I've seen some really good inspections from agents who really know what they're doing and who are not going to get sued. And then I've seen a lot sitting on my desk in a file because they did really crappy inspections.
Oops. Yeah, I'll admit I've not taken this seriously. I'm just not personally very mechanically inclined. So for me, it's not my strength, and I need to take it more seriously. Well, thanks for the reminder on that.
I mean, look, you're a real estate professional, right? You're licensed by the state to do these things. And one of the things as a real estate professional licensed by the state of California that you are required to do is this inspection. And you're required to do it as a professional, whether you've been doing it for 1 year or 20 years. And there's a minimum standard for what you should do. And it's a visual inspection. You don't have to test the plugs. You don't have to turn on the faucets. But, you look up at the ceiling. I mean, I've walked into rooms where I can see what's there. And I'm looking on the inspection that took place 6 months earlier. And, it's not noted. And it's obvious if you look.
Okay, I'll look more carefully. Sorry.
Sorry,
Jack.
I don't want to represent you.
Yeah, I've never been sued. I really haven't been threatened to be sued, but I think partially because I get people to do their jobs, and frankly, I get another agent do the AVID most of the time these days.
You know what I tell every one of my real estate agent clients who tell me I've never been sued before? I tell them you can't say that anymore.
Why?
Because they're my client because they got sued.
Oh, got it. Uh-oh. Okay, I won't say anymore. I want to be a client, but I don't want to get sued. So maybe there's some other program. So let's talk about real estate. Oh, there's Patricia Castillo with her hand up. Let's bring Patricia in the call. Let's see, unmute her. Give her the power to unmute herself. And what's up, Patricia?
Hi, Bill.
Patricia.
Hi, Jack. How are you?
Good. How are you?
I'm doing great. Thank you. So our broker is Debbie Penny. She's,
Dun.
Yeah, she's fantastic at giving these, instructional classes every Wednesday. And she's been also driving home the importance of having the AVID completed. She did make mention in one of
Now, hold on. You can't report to her. I just said on this call. This is between us.
Yes, this is blackmail. This is my blackmail. So
not like it's live on the internet.
Right.
I'm going to edit that part out. I'm going to cut this out. It's my content, Jack. I do it the way I want to do it. Go ahead, Patricia.
So she just, she made mention recently that if you're the listing agent, you're representing the seller, that the listing agent should be completing the AVID rather than having maybe a, stand-in agent go and complete the AVID for you. Maybe you have another agent that you're partnering with to Bill.
Patricia's probably done 2 or 3 for me on deals. Yeah, go ahead.
So I'm just, I just wanted to see, is that something that you see a lot where there's issues where the listing agent says, I didn't complete the Avid form. I had a partner agent complete it for me. Or maybe the listing was in another county, and so they had a local agent, maybe in the same brokerage, go and complete the Avid. Have you had any issues like that come up?
Well, who's signing it?
The agent that prepared it.
And the broker.
Okay.
Right.
Well, I think the issue you run into, there's no problem with that in a general sense. But in the situation where something goes south, the listing agent is going to be responsible for making sure that the inspecting agent did their job. And there's really no way to do that unless you go out and look at the property. So is it the wrong thing to do? No. Does it add more risk to you, A, getting sued, and B, having a hard time defending that suit? Yes. It's not the optimum thing for you to do if you're the listing agent.
Right. And I know that comes up a lot. Like, we're licensed, our jurisdiction is the state of California. I'm in Los Angeles. So if I have a client that refers me a listing, let's say in San Diego, it's 2 hours away, not too bad of a drive. But if I had a partner agent, we're with eXp Realty. So if I had a partner agent in San Diego perform the Avid and fill out the form and sign it, and something comes up, a year from now, then I would have no idea what the issue was because I never, I hadn't seen the property.
Right. And I'm not saying it's necessarily a bad thing. And if I was representing you and you got sued and they say, oh, well, the Avid didn't show it. And, you would just bring in the other agent and have them testify as to the inspection they did. And, some might argue, well, it was your responsibility to do the inspection, not them. But I don't think there's a lot of truth in that. It's adding another layer of issue for you to have to deal with if it goes south. Look, I only see these cases when something has gone wrong. 98.9% of transactions don't result in a lawyer ever having to look at them. And I'm just going from the 100% of cases that I looked at that were lawsuits. So all I'm telling you is the percentage chance of you getting in trouble for having someone else fill out the Avid increases. That's all. And how much does it increase? I don't know. There's probably a very small amount, but you do enough things that increase your chances, and eventually you may get yourself in trouble.
Well, I think you would say that ultimately it's the broker who's responsible, right? And the broker delegates to the agent, and then if we as the agent in turn delegate to another agent, the broker is right to hold us responsible, the other agent. But from a lawsuit point of view, it really is the broker who is going to be responsible. So, our broker is over 10,000 real estate agents statewide. If she has a policy, you either have to follow the policy or you change companies. It's her prerogative. She allows us to do it, then we have to do it properly. We can't just pawn it off on somebody who doesn't know what they're doing. So,
right.
Very good. Okay, so Patricia, the Avid you did for me, are you suggesting I should go back out and reinspect the property?
No.
Okay, thanks.
No. Just going forward, yeah. Just it's good to know that because as Jack mentioned, the real estate agents need to take that disclosure a lot more seriously and really pay attention to it.
It's funny you'd come in on that because I happened to be at the state meeting this morning for about 10 minutes, and that's the part that I heard. So, and I went to ignore that, but you reminded me. So thank you so much, as always, Patricia.
Absolutely.
Thank
you,
you.
Jack.
Thank you.
Yeah.
Okay, so we have Daniel Recedo has his hand up. Let me get him unmuted, and let's get him in the call here.
Hi,
Go ahead,
guys.
Daniel.
I had a quick question. I've listed some properties that I've put on there as is with no warranty. How much does that cover by adding the no warranty?
I would say it gives you a bit of protection, I suppose. It's really, if you know that there's something wrong with the property, even if you sell it no warranty, you're opening yourself up to problems. My whole practice is set up for litigation avoidance. And I think if you sell something that says no warranty, but there's still something you knew or should have known, you're buying yourself some trouble. Now there's a difference, for example, when adult children sell the home of their parent who passed away, and it's a home that the children never lived in.
Right.
There is some protection for that sort of situation where you can say, I've never lived, there's parts of I forget which form it is, you don't even have to fill them out because you never lived there. So there's that kind of no warranty that you actually do have legal protections. If I were advising you, if I was your lawyer and I was advising you, I would say you have to have a really good reason to say no warranty. Because if I was advising someone who was looking at that property, I'd say, okay, why are they saying no warranty? This is, is it just a residential property, a house?
Right. Just a residential house.
Yeah, I would be like, why is it no warranty? That's just a huge red flag. And so everyone's got their antennas up, really on both sides. And I think you end up, go ahead.
No, I was going to say, so if I put it as is no warranty, but disclose everything, that would help a little more, wouldn't it?
If you disclose everything, what's the point of saying no warranty?
Just so in case, like you said, everybody can sue for anything.
Yeah, that's not going to protect you from getting sued.
Gotcha.
It's not a matter of whether you get, for the defendant, it's not a matter of whether I'm going to win the case. It's, I don't want to get sued in the first place.
Right.
And so saying no warranty, that I in my opinion, doesn't really give you any protections. I mean, I can't think of a situation where it really does.
So
I think
basically, it comes down disclose.
Yeah.
I think this is an area that's really this is where there's misunderstandings because of lack of reading the underlying document, because our basic residential purchase agreement forms, all of them,
yeah,
they all say the property is as is condition.
Yeah, correct.
And so writing as is almost always not only duplicative, but could be misleading if you add other words in, because what do the other words mean in the other context, right? So by definition, if it's clear and you add anything, all you can do is add some degree of ambiguity. And then on the seller side, it says in black and white, the seller is agreeing to disclose everything in the standard default form. So unless you say, we're not going to disclose anything, there are certain exemptions when you're not obligated to disclose what you don't know. That's different. But you're obligated to disclose anything you know, unless by the default of the contract, right? Mm-hmm. So you can negotiate, I guess, whatever you want. But if the default says you have to disclose everything, now you're stuck with it's as is, and you're disclosing everything. So I think sometimes agents not knowing those two phrases are baked in, you need to explain it to your customer so they can say, well, this is where we're starting from. We're starting as is. We're not starting from, we're promising everything works perfectly. It is as it is. And let them inspect and determine what that is.
I had a case once where it was a commercial property that was sold, and like the buyer was like, I don't care what condition the building is in. I don't care about anything. I'm waiving everything. I'm waiving my, I'm releasing the deposit. It's all fine. I just want to close the transaction. And they did. And they came back and sued because of problems with the building.
I just had one like that.
I mean,
exactly,
the documents couldn't have been clearer, and they still came back and sued. So it goes back to, yes, you can sue for anything. I got it knocked out, but it took time away from my client doing what they do for a living, and having to meet with me, do discovery, take depositions, assist me in writing a motion for summary judgment, and doing all this stuff when they could have been making money doing something else. And that was one where it was so clear. It was ridiculous.
Yeah, I mean, they waived everything completely.
Yeah,
and they still have the opportunity to sue.
Yep.
I had a case where a buyer was buying a property, and originally he was going to knock it down to build a whole new structure. And mid escrow, he decides, or I guess towards right before closing, he decides, actually, turns out I can do blah 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 and remodel it and whatever, make it work better and more effectively. Well, all of a sudden now, all those disclosures are a different story, right? Because now he cares because what do you know about the property kind of stuff. So good. Okay, good. Daniel, nice seeing you, man.
Hey, nice seeing you.
Love the picture
Okay.
behind you. Now, which one of those?
Actually, I designed that when I worked for Disney. That's one of my first designs that I did for Disney, for Walt Disney
Oh,
Studios.
wow.
Yeah, I was a art director there
Oh,
for
wow. How
several
nice.
years. So
Man,
that's
you're a
why I have
sailor.
it. That's why I have it up.
A man of many talents, like Jack LaPedis, a man of many talents. Thanks for coming in.
All right, talk to you soon.
Okay, anybody else has any questions, feel free to either raise your hand or put a question in the chat box. Always best to put a Q before if you have a question. It's meant to be participative. And, Jack is a great resource. He's been on my calls for the last couple of years, fairly regularly, and is always able to jump in and answer questions. And oftentimes I'll say, well, I'm not an attorney, but, and then he'll jump in and answer the question, which is great. So feel free. And we want you to learn on the call. If you're on the live stream, if you put chat questions in the chat box, if there's something that I can't answer, I can reach out to Jack and have him answer them afterwards if he's up to that. And then in the chat box, he put in there that he has a hobby of collecting old but working or broken Apple hardware, iPhones, iPods, iPads, AirPads, the whole gamut of it. And he'll take them and I'm not sure what he does with it, but whatever he does with it, he collects that stuff. I know I have a whole trunk. Someday I'm going to donate it all to.
Me too.
I'm negotiate legal fees someday and give him my Apple product.
Well, what I do, I have a collection. I call it my nerd museum. I collect them, but I get a lot of duplicates, especially of phones and MacBooks. And if they are in good enough condition, I actually have a guy who helps me out. He replaces the parts for costs. He doesn't charge me for labor. And then I find people online, either through Nextdoor or Facebook groups, who need technology, and I donate them. And in fact, last weekend, I donated 8 iPhones to people on a group called Buy Nothing, which is a place where people go and donate things. And so people who don't have the technology they need get it. And every once in a while, I get something I get to add to my collection. And I'm just kind of an Apple nerd. And I enjoy playing with this stuff and having it and being able to help people out with it as well.
Do you display your collection anyway, online or?
I do. It's actually my iDevice collection is right up there behind me, but I'm not going to be I'm not going to turn him off. And then my
He's so serious looking. He scares the hell out of me.
My computer collection is on a couple shelves in my garage. So I do display them to some extent.
And how many computers do you have?
I don't know. I actually have been meaning to do an inventory, but I haven't. And I've been meaning to update my photographs. I take photographs of my collection.
Oh.
This is an old picture.
Wow.
Of my computer collection. It's probably twice as big as that right now. And then this is an old photograph of my iDevice collection, and it is certainly double that. I actually have about 7 iPads now, and in that picture I had 1, and I probably have 20 different iPods.
Wow.
But I'm hoping to get to this.
Wow.
Do they all work?
Yeah, everything that I have in my collection works, except for one. I have a Mac SE that has a bad hard drive, and I'm not willing to spend the price for a new hard drive because they're very expensive to get the hard drives that work in there. So that one's just for looks. And I have one computer I haven't tried to boot up yet, but it just looks pretty, so I have it sitting there.
That Mac SE really changed the world when it came out. It was really.
That was my first computer. Yeah.
Wow. I lived in Boca Raton, Florida. I moved there when IBM first moved their production facility from Armonk, New York to Florida and at the time, and younger people don't know this, but before Apple was a dominant computer, the standard computer was IBM PCs. They really created that genre of home computer. Apple kind of came in right behind them or made it more consumer friendly. But the IBM PCs were just amazing, and I was in Florida during that kind of gold rush era. Okay, any other questions? So there you go. If you help him out with his collection and or donations to people who might need products, feel free to reach out to Jack, and his information is in the chat box. And then Jack, if somebody is in a business dispute or real estate dispute, as we discussed, what's the best way to get a hold of you? I see your contact info in the chat box. Is that the best way?
Yeah, send me an email is probably the best way. And that's jack@lapeduslaw.com.
Great.
And that is monitored 24/7.
You know,
Not
just
necessarily
say,
by me.
I refer clients to Jack, and in some cases he's done a great job. In other cases, he's referred them to maybe a specialist in an area I didn't understand clearly what he did and didn't do, and he found somebody else who did something more specialized that did take care of the client. So I think it's one of the things that I appreciate about him is I'm a specialist. I do what I do really well. I don't do things I don't do well. I refer him to somebody who does, and I think Jack does the same thing as an attorney, and so I really appreciate that about you. And more than that, I appreciate you being on the call and sharing with everybody today. So thank you so much, Jack.
Yeah. So it looks like Maisha was either on the bus or the train, has posted a few questions. Do we have time to touch on those?
Sure.
Okay. Do you have to be, or have you been a real estate agent to become a real estate attorney? No, you don't have to be, but when I was representing real estate agents, I decided I wanted to go through the process of becoming a real estate agent just to see what that was like. I did the studying and I took the test and I had the license, and then I let it go after a year. I didn't need it for anything. And I decided not to get the broker's license, and I don't need to do that. So, but you don't have to be a real estate licensee in order to be a real estate attorney. Do real estate attorneys meet or work with entertainment lawyers? Yeah. I mean, if the situation comes up, I know a few entertainment lawyers, and if they have a client that has some sort of issue. In fact, one of the cases I handled at one of my older firms, the plaintiff was a huge music star who had a whole team of lawyers, including entertainment lawyers, and we had to litigate against. And just in that situation, I don't know if it's true for others, but most of the lawyers were really bad at their job. Most of the lawyers that were representing this multi-millionaire music mogul were really bad at their job. And I found that shocking. I would think that those people would be really good.
I think in most businesses, there are people who focus on getting business and other people who focus on doing a good job. And it's rare that you find people who do both well.
Right. She asked if do real estate attorneys work with private investigators? Yeah, I've hired a private investigator or two in my time to try and find out where somebody is, like an owner who's on title but has disappeared. I also recently hired a private investigator to try and help me find assets for an opposing party that we were awarded sanctions against, and they weren't paying, and we weren't quite sure how to get those sanctions recovered. And so I hired a private investigator to try and track down their bank accounts and things like that. Are a lot of agents also insurance agents? I think you mean a lot of real estate agents are also insurance agents, and yeah. I would say no. I've actually never seen any crossover between real estate agents and insurance agents. And actually, I've represented insurance agents also. I've done insurance malpractice defense, and I would say that they are both entrepreneurs, but in a very different way. I think that insurance agents feel more like salesmen to me, and I don't mean that in a negative sense. I just mean that in a general sense. Whereas real estate agents, I feel, are a little more entrepreneurial. I don't know if that makes a lot of sense, but in my head, there's a division between entrepreneurs and salespeople. So that's the difference that I see between those two industries that I've worked with.
Interesting. There is some crossover. There are some big insurance companies that encourage their insurance practitioners to think more financial wealth management. And I know Fortune Builders, I know Transamerica, there's within those organizations, they have, there's a movement to get them to also be real estate agents that do occasional deals or referral income as a source. So it does happen.
I'm sure it happens. I just literally never run into it.
I think there's more of it going on than you know. It's just that the people who do both don't do much of either, and it's hard. It's hard to do both. It's harder, it's hard to do one really well. It's hard to do both at all. And So there are people who are, and nothing wrong with it, but I'm just saying, generally speaking, that's a tougher way to go to make money.
Well, if you think about the people who are successful in either industry, they are all in that
Yes.
industry. And if they try to do both, I would feel like, that it'd be too much of a division. They wouldn't have enough hours in the day to be successful at both.
Generally, I think you're right. There's probably exceptions. One of the exceptions might be Pamela. She's jumped in here and she had her
She's
hand
gonna
up.
set us straight.
She's ready to punch us with her hand up there. Okay, Pamela, go ahead.
No, I was just going to agree. You're absolutely correct. I've been a real estate agent for 17 years. And I was also for a period of about 6 years an insurance agency agent. And you're absolutely correct. It is very difficult to do both. And you do feel different. It's a totally different type of focus and motivation. When you're an insurance agency, you almost feel like you're working in corporate America, like your mindset is not free. It's almost like you're enslaved. So I wouldn't suggest anyone try to combine that. Because you can't do it both. It's totally two different minds, and you just can't be effective. I did it because I thought it was like, we'll offer like a one-stop shop to my customers. I can sell their home, but but it ended up hurting them. So I allowed my license to not activate them anymore after I saw I couldn't do both. And even with investing, sometimes I feel almost enslaved by my license, because I'm like coming up there literally in 2 weeks to take the California state exam, because I live in Georgia. I'm licensed here, but I'm coming up there and I'm supposed to take the California state real estate exam on the 16th. And I almost feel like I'm putting another rope around my neck as far as investing. So I just wanted to ask the group, I don't know if any of you guys have licenses. Do you find it more difficult as far as disclosure? Because you're an agent, you have to disclose everything, even when investing. So I'm just kind of feel like I've gotten myself with these licenses. I've been trying to take them for 3 years in California, and that exam is a killer. And so I'm just wondering from you guys, do you find it holds you back when you have a license as a realtor in California when you're trying to invest?
Are you going for the broker's license or agent's license?
Agent, because I'm already an agent here in Georgia, but
Right.
I'm trying to move to California. I'm trying to move there in a few months, sometime at the beginning of next year. And so I just wanted to, have a license just in case. I don't even know if it's necessary. I know it's not necessary to invest, but I don't know what I need to do. But the test is on the 16th, so.
First off, I'm relieved that you agree with us, Pamela. I'd hate to have you in disagreement with us, for starters.
Yeah, I agree.
Second, I had my insurance license and let it go because I found it hard. I went to have my mortgage license, and that was the same license in those days. And I found it too hard to do either one and be great.
Yeah.
I could be better than average at both, but couldn't be great either.
Mm-hmm.
And I don't know, are you a real estate agent in Atlanta? Are you with a company there?
Yes, I'm a licensed I'm with VPR, Virtual Properties Realty. But my passion has always been real estate investing. I got my license as a realtor here in order to invest, because when I first got my license 17 years ago, I was told that it would be advantageous to have your license. So I joined a brokerage that specialized and worked with real estate agents that wanted to be investors. So I've had them for a while.
So I'm sure Jack can give us a legal side. As a career side, I think two things I would say is, one, you should focus on what your primary business is. Either it's an investor or it's a real estate agent. And that should be what you decide. What's going to support that business first? If your goal is to be a real estate agent, of course, you have to have a license. If your goal is to be a real estate investor, the license is extra education and it can give you extra authority. You have to be careful not to misuse it. So if you're approaching homeowners as a principal, you don't need to disclose it until you're in a contract. If you're approaching them to list their house and encouraging them to use as an agent, then they're giving you information. Once that starts, you really can't change the process and become an investor on that deal. That would be a violation of your ethical responsibility to the prospect. So you have to think about how you're going to run your business. And I would say in general, getting a license or not, either one would work from a practical point of view. It depends on how you're running your business and how you see it. I'll give you one last thing to consider. Is I'm with the XP Realty. We're one company nationwide. You have to be licensed in any state you want to do license activities, but you only join one company, so you don't have to pay caps or commissions to two companies and have two company procedures. Of course, if you do license activities, then you're restricted in the state by what you can or can't do. Jack, any thoughts? What do you think about real estate investors who are licensed? Do you see the issues as far as disclosing that, not disclosing it properly? Do you see those issues?
I haven't run into that issue in my practice. It's really not the kind of thing that has come up, that someone was a hidden agent or something, anything along that nature. And it would really be sort of a secondary issue, and it really would be an issue between the licensee and the licensing board. I don't think it would end up being something that you could be sued for. Oh, they didn't disclose they were a real estate agent, that caused me damages in some way. Because really, in addition to that, you can sue for anything, you still have to show that you were damaged by whatever activity you're suing on.
Yeah. I think it's something that people concern themselves with, and if you act appropriately, you'd stay out of trouble with. But I think the bigger issue is what's your business, and what's your business need to do. And if you're buying properties in California as a principal, there's no reason why you need a license. You would save the commission dollars, if that's important to you. If you're getting investors to invest in property in Georgia, there's ways you can do that and not need a license.
Yeah, I just feel that it would just entrap, because I feel entrapped here in Georgia. I actually feel there a lot of pressure and just like to always. So I sought out to get these licenses like 3 years ago before COVID. And you know how I've already paid for the license and all that kind of stuff. I really, honestly, now that I'm focused on my wanting to be into investing full time, I kind of don't even know if I want them now.
There you go.
I've been studying for the test for 8 months because it's a killer. But yeah.
Well, don't throw good money after bad, and you can get the license and then not join the local board or not join the MLS, because it's another $1,000 a year that you would need to spend, and most companies require that too. So something to think about.
Okay.
If I can help
Bill,
offline, let me know.
Bill, before we wrap up, I know we're getting towards the end. There was something I wanted to bring up earlier, we didn't come back to it. Disclosure is about knowledge. If the person already has the knowledge, they're not harmed by a non-disclosure. So if there's something, let's say there's something obvious in the house, that is a problem, that you walk in and it's right in front of you. And I wish I could think of an example, but it's completely escapes me. And that problem, whatever it is not disclosed by the seller or the agent. Of course, you can be sued for anything, but you're not going to win saying, oh, you failed to disclose this obvious problem. So just again, disclosure, and I've had this argument with attorneys who's like, well, they didn't disclose it. I'm like, yeah, but they already knew it. The fact that they already knew it negates the need for the disclosure. There's no damages from the failure to disclose. So that's another important thing to keep in mind when you're talking about disclosure, is that it's about what knowledge the buyer has.
There you go. From a real attorney too, not a fake one.
I don't even play one on TV.
Pamela, thank you. Jack, thank you so much for your continued support. And for today especially, I really appreciate you being able to share with us real legal advice from a real attorney, but also somebody who's understanding kind of what our market is and what our process is, because you're here on a regular basis. So thanks so much for your constant support in that area. I really appreciate it.
But of course, nothing I said today is legal advice.
Yeah, you can't rely on any of it yourself. And even if you hire Jack, you can barely rely on that. So just be careful. Did I just say that?
Just ask my clients.
Did I just say that too? That seems so rude. Okay, well, thank you, Jack. I love you, appreciate you so much. And for the rest of you, just real quick, 2 events I want to bring your attention to. If you're a real estate agent, we get together every the first Thursday of the month at All Season Brewing in Los Angeles. It's on La Cienega, near just south of Wilshire Boulevard, the former Firestone building. And if you come and you're a licensed agent or an attorney, Jack, and mention this call, your first beer is on me. Love to have you come. It's Thursday, 5:30, and the information is in the chat room if you want to come to that. Love to have you for that. And then also, if you're a real estate agent, again, this is not for investors, this is for real estate agents. On Friday in Diamond Bar, we have the Agents Helping Agents program we do. And we get together, about 40 of us, and share what's working, what's not working, and hopefully get together, hold each other accountable, push each other to be more successful in business. That's in Diamond Bar, Friday morning. It's the first Friday of the month, and free breakfast included as well. If you're driving, you don't have a chance to write this down, feel free to text the word upcoming, 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 for upcoming events, to 213-460-2577. Again, 213-460-2577. Type the word upcoming, you get a list of our upcoming events, and we'd love to have you participate with us on Thursday or Friday. For the rest of you, thank you so much. Again, Jack, thank you as always. I'm Bill Gross.
Thank you.
This is our LA Real Estate Investors .com podcast. We do every Tuesday at 3 p.m. Pacific, 6 p.m. Eastern time. We live stream it on Facebook and YouTube, and appreciate everybody. Thank you so much, everybody.